Focusing a little bit on the ICTY, which is under a Security Council mandated completion strategy. And what this is going to involve is the creation of a residual mechanism, which will be essentially a roster of judges that will be deployed when necessary to sort of do cleanup, essentially, on some of the cases. So the ICTY will continue with a limited staff on the current cases, the high-level cases. Lower cases were meant to be transferred back to national authorities. Those transfers have happened. And then this residual mechanism will handle sort of ongoing things that come up, such as new evidence and review questions, motions to review judgments based upon evidence. Contempt proceedings, right? Proceedings where they're involving interference in the process of justice. Parole questions. These will all be dealt with by this residual mechanism. It will not be empowered to issue new substantive indictments involving the former Yugoslavia, but it will be able to issue, for example, contempt indictments if there are allegations of witness tampering or retaliation against witnesses. The big news of the ICTY, and this is an incredibly important development in the international criminal justice movement, is that now every individual under indictment is in custody. And with the capture of these last two individuals, that sort of, crossed the last people off the list. So Mladic, we'll hear a little bit about at lunch today. He was the second in command behind President Radovan, quote-unquote, President Radovan Karadzic of the Republika Srpska, a self-proclaimed Serbian entity within Bosnia and Herzegovina. And then Goran Hadžić, who is charged with ethnically cleansing the Krajina region between Bosnia. It's a Serbian, there were a number of Serbian individuals living there, but it was at the border of Croatia. And he is alleged to have cleansed that area. So that's what that indictment concerns. Another case I want to just mention is this case against Gotovina, which is in many respects the inverse of the Hadžić case. So Hadžić is accused of cleansing the area of Croat residents in order to create this Serbian enclave. Gotovina is accused 4 years later of re-cleansing the area of Serbian inhabitants who had moved in after the Hadžić cleanse. Now, what's interesting about this case is Gotovina received a lot of support from the United States in implementing what was called Operation Storm, which was billed as an effort to reassert constitutional control over the Krajina region and essentially take it away from this self-proclaimed Serbian political entity. He had assistance of drones, he had targeting assistance, he had certainly training, weapons assistance. The full extent of the United States involvement is not fully known, but it's very clear that we had a real interest in him not only succeeding, but doing it in a way that was completely clean under the laws of war. And in fact, the tribunal found that 95% of the targets that were the subject of Operation Storm were in fact military objectives and that proportionate appropriate amounts of force were utilized. Nonetheless, with respect to these other sort of 5% of areas where there was artillery used, the court concluded that civilians were purposely targeted through the implementation of Operation Storm. And that ruling then serves as the sort of foundation for a number of other rulings. So Operation Storm coincided with a massive exodus of the Serb populations of the region. And the question is there causality here, right? Were individuals being targeted such that they left, in which case we charged the crime of deportation through an unlawful attack against civilians, or did they leave prior to Operation Storm because they didn't want to they wanted to avoid an armed conflict, they didn't want to deal with Croatian authorities moving in? It's very unclear the timing and the evidence of this, of the way things kind of went down in these short periods, a 2-day operation. The trial chamber has convicted on the basis of a finding that Gotovina, was part of a joint criminal enterprise to purposely target civilians. And all the other findings of criminal liability hinge on that finding. So my sense is that this is ripe for appeal, and it would be very interesting going forward to see how an appeal ends up playing out. There's another interesting case here, just as more of a legal point that just might be of interest given the way in which we've structured the system. In the U.S. system, we have 3 tiers of appeal. We have a district court, a lower court, a court of appeals, and then we have ultimate authority of the Supreme Court. In our systems in international criminal justice, there's usually only 2 levels. So So this individual, Silvanchichin, mispronouncing his name, I'm sure, was convicted by the trial chamber, the lower chamber, involving an incident in which a hospital in Vukovar, all of the patients were taken out of that hospital, taken to a detention center, mistreated, and then executed. And he was charged under a command responsibility theory of soldiers under his command of the Yugoslav National Army participating in that. The trial chamber found that he couldn't be held responsible for the murders of these individuals, but he could be held responsible for the mistreatment because he knew that his troops were there, he knew that there were going to be paramilitaries working there as well who had been associated with abuses in the past, and he failed to prevent the harm or to punish it after the fact. The appeals chamber actually reversed the acquittal on the murder charges and imposed a murder conviction. So on appeal, his sentence was actually increased from 5 to 17 years. In 2010, he applied for review of that judgment by the appeals chamber on the theory that there was new evidence that he didn't know that his troops were not going to be there and that there would be paramilitaries there. And on appeal, the appeals chamber, looking at this anew, in light of this new evidence, said in fact the conviction for the murder charge was a miscarriage of justice, and so it reversed itself. Now, what's somewhat controversial about this is this idea of the appeals chamber being able to enter a conviction, and he has no right of appeal from that conviction. And this judge, Judge Fausto Proccar from Italy, has consistently dissented from this practice of the ad hoc tribunals on the theory that all of the omnibus international human rights treaties protect a right of appeal of individuals who are subject to conviction. And when the appeals chamber enters that conviction, there's nowhere to go. There's no higher court to seek appeal from. And so he's constantly said, actually, what should happen is we should remand, send it back to the lower court, let them enter with our instructions, essentially, and let them enter the conviction. So we may have had a sort of clarification here and a fix here, but this possibility of infringements on the right of appeal remains very real.